Good morning, ladies and gentlemen, and thank you. Raphael was talking about one particular regulator, the energy regulator, and what I want to talk about in this short presentation is a proposed new regulator, and that is the Planning Regulator. I was speaking with a colleague last night, and he didn't even know there was a proposal for a planning regulator, but many of you will be aware that there is. This is effectively, in this paper, what I want to do is to explore some of the issues around this new proposed planning regulator. It is, of course, a legacy of the Planning Tribunal and the corruption within the Irish planning system, which is fairly well known at this stage, which it uncovered. And one of its recommendations, not its only recommendation, but one of its key recommendations is the establishment of a new planning regulator. And the current government probably didn't have much option, but has clearly indicated it is going to accept that recommendation, and it is going to implement the planning regulator. And the draft legislation is imminent, by all accounts. In fact, when Owen asked me to speak on something, I said, I'll speak on the new planning regulator because the new legislation, or the draft new legislation, will be out. But of course, that didn't materialise. Fairness, the Attorney General's office may say they have more pressing or interesting things to be doing at the moment rather than finalising this legislation. But I certainly think you will see draft heads of bills in relation to a new planning regulator published within the next couple of months. And for reasons which I'll explore a little bit later, it is extremely important that this legislation be carefully considered and scrutinised by anybody who has any remote interest in the future direction of Irish planning and the future shape of the regulation of Irish planning. So, just to look at the background, of course, is the Tribunal of Inquiry into certain planning matters and payments, which all of us, all the Irish people in the audience will remember fondly, variously called the Magnaflow Tribunal. There were two judges involved, Judge Fergus Flood, and eventually Judge Mahon ended up finishing it off. The final report published on March 22nd, 2012. The tribunal sat for well over a decade, I think, and its final cost, most of which went to lawyers, is, yes, 250 million between 300 million. So almost £250 million expended on this report. Now, that's a separate issue as to whether that was value for money or whether it could have been done in a better, it clearly could have been done in a better, more efficient, cheaper way, be that as it may. The objective of the tribunal, of course, was to investigate the fairly widespread allegations of corruption in the planning process in Dublin County Council in the late 1980s, early 1990s. More specifically, what the tribunal was looking at was the allegation of effectively payments to elected representatives to secure the rezoning of lands in contrary to the advice of professional planners. Now, just to digress, I would assume that most people in the audience will understand within the Irish planning system there is a key role for the local elected representatives, that is the county councillors or the town councillors, who are responsible for formulating under the Planning and Development Act the development plan. That is a reserved function. They are responsible for preparing that plan. There's a public process. The professional planners within the organisation prepare it, but the ultimate decision on to adopt the development plan and its format is with the local representatives. And of course, part of the development plan, not exclusively, but a key part of it, is the zoning of lands. And zoning is a key instrument in land use planning, whereby you allocate particular uses for particular areas or tranches of lands. There's nothing wrong with zoning, it's an essential tool. And obviously it makes a huge difference if an area is zoned residential or commercial, residential or mixed use. It therefore has a certain value, the land. If it's zoned for high amenity use or has a restrictive zoning, therefore it has a lesser value. And obviously if you can effect a change in the zoning, therefore you have a potential windfall. Now, the Man Tribunal, there's Judge Mahon, eventually published its findings about 2 years ago at this stage. It made a lot of specific detailed findings in relation to specific zoning decisions, which we needn't concern ourselves with, but are obviously of significant importance.
but it reached some fairly chilling, if not unsurprising, general conclusions. Judge Mahan said he had uncovered evidence of a deep-rooted systematic corruption in Irish life surrounding the planning system, and he was satisfied that for some councillors, at least in Dublin County Council, corruption had become a regular aspect of their public role. So the tribunal affirmed what had been fairly widespreadly believed, that within Dublin County Council for that particular period of time, councillors had been bribed, and let's put it to be clear, bribed, to exercise their statutory powers in a certain way to rezone land for the benefit of certain landowners and certain developers. And that's simply the situation. And in many cases, those decisions of zoning were made contrary to the advice of the professional planners, and therefore were contrary to proper planning. So areas that were zoned residential should never have been zoned residential. And there are knock-on consequences to that going forward. The particular example that's often cited is the Quarryvale or Liffey Valley decision, whereby the town centre identified in the plans was located in a different location, and there are people who will argue that that was to the detriment of the local community ultimately. Now, the Man Tribunal then made a number of recommendations, all of which were designed to control the powers of elected members in the planning process. Now, the interesting thing, what Mahan accepted, and what he didn't do, is what a lot of people were looking for, and a position which I would myself have had a little bit of sympathy, which is, some people would have suggested, well, let's just remove all the planning powers in terms from local elected representatives. They've proven they're not in a position to deal with it. They've proven historically that they've behaved badly in relation to it. And let's just take it away and let's put it into a non-elected technocratic body which will make decisions. Now, Mahan didn't go down that route, probably correctly in the end. And he said, look, I'm going to remain with the idea that the local decisions on zoning or planning and the formulation of a development planning should remain with elected representatives, but there must be a new layer of controls, a new form of controls to ensure there's no misbehaviour or corruption going forward. And amongst the recommendations he made, apart from the appointment of a regulator, were a requirement that where the elected members of the planning authority exercise their powers under the Act, and apart from the recommendation of the city or council manager, they should be required to state reasons for so doing. And he also made a number of other recommendations in relation to giving enhanced powers to regional authorities to get involved in the development plan making process. Now, these changes have been implemented in the Planning and Development Amendment Act 2010. In fairness, John Gormley of the much maligned previous government did introduce significant changes, including the changes in relation to the core strategy requirement in the development plan, which some of you will be familiar with, which is that every development plan has to contain a core strategy which indicates how the plan is compatible with national and regional plannings, and also a much greater enhanced role for regional planning authorities in the development plan, which means that hopefully the chances of a development plan being passed, notwithstanding the efforts of local representatives, which is incompatible with either regional or national plannings, is greatly reduced. And to a large degree that addresses a difficulty or concern identified in the Mahan Tribunal. Now, in relation to his recommendation as to the regulator, he recommended the establishment of a planning regulator who would assume some of the powers currently exercised by the Minister for Environment, Community and Local Government to give direction to regional authorities and planning authorities under the legislation. And at the moment this power is primarily in terms of development plans exercisable pursuant to Section 31 of the Planning and Development Act. Now that, so to speak, is kind of one of the nuclear options available to a minister in terms of a non-compliant development plan. And that power, in fact, has been in existence for quite some time, but was relatively lightly used or rarely used until recent years, when it has been used much more actively. And basically it allows the minister to give a direction to a particular plan, say your plan is incompatible with proper planning and sustainable development, with regional planning and national planning guidelines, and I'm giving you a direction which you have to comply with to change your development plan. by doing A, B, C, and D. And in many cases, this has required the reversal of decisions in development plans relating to zoning or inappropriate zoning designations in development plans. Now, the power is contentious, and the reason the power is contentious is because it's essentially the exercise of a political power by a particular elected political office holder, the Minister for Environment of the time, imposing that on other political representatives. And that can be contentious for self-evident reasons, and particularly in circumstances where the Minister is a Fine Gael or a Fianna Fáil Minister, and the Council is a Labour or a Fine Gael County Council, and they see this as a political interference with them. And also, for wider reasons, local authorities or local elected representatives resent imposition politically of changes to the development plan. But be that as it may, the power still exists in relation to Section 31 and has and is being used and represents an important control. But Mahon recommended that this power be transferred to an independent regulator, and I think he was concerned about the political dimension to it, feeling that it would be better that this power would be exercised non-politically by an independent regulator. Again, this is the tribunal envisaged a slightly wider role, and I've included that extract there. Obviously, he talks about the tribunal is recommending the regulator should be entrusted with the power to investigate possible systematic problems in the planning system, including those raising corruption risks, with the aim of making recommendation to address those problems. It goes on, the regulator should be responsible for providing training to members of both local and regional authorities on planning and development to enable them to discharge their functions in this area more effectively, and I'll talk about that a little bit more later on. And then finally he concludes by saying the regulator should have sufficient powers to carry out his or her functions effectively, including the power to question witnesses and compel the production of documents. And I think that latter recommendation or element which I've highlighted is a very important aspect of the recommendation in my submission. So just to look then a little bit more at what Mahon recommended, he recommended the power to investigate possible systematic problems in the planning system. I think that what he was looking for here, or what he envisaged the regulator would do, is have an oversight function in relation to planning authorities, and through research, through audit functions, and through spot checking, would be in a position to pick up trends or identify difficulties in the planning system, or trends relating to for example, inappropriate decisions on zoning, etc., in relation to it. He also recommended that it would have the power to make recommendations to address problems in planning system relating to corruption. He also envisaged an educational role, also veering into research, which would again involve providing training to members of both the local and regional authorities on planning and development to enable them to discharge their functions in this area more effectively. And I think the idea there would be that the regulator would be, providing clear standards and clear educational advice to the elected members as to what their statutory functions are and what their powers are in this context, and what they should and should be doing. And again, important that throughout the report, or in the report, it's made expressly clear by Judge Mahon that the regulator must be given the sufficient powers to carry out his or her functions effectively, including, I think, and stressed, the power to question witnesses and compel the production of documents. Now, the Man Tribunal, when the report came out, obviously, it was, I think, universally, there was no great surprise to the report having regard to the interim findings of the report, and obviously, as many of you will know, there was a huge degree of publicity surrounding the hearings. There was very significant political fallout for certain individuals arising from the findings of the tribunal, or even the hearings of the tribunal. So the findings of the tribunal generated a significant degree of public debate around the planning system. The government at the time obviously welcomed it and didn't really have much choice but to implement the majority of its recommendations, and accepted in principle the key recommendation of an independent planning regulator. And I don't think there's any opposition
within the political system to such a move now. Whether or not there may be some debate surrounding how this is to be achieved. In any event, in May 2013, about this time, well, in or about this time last year, the government announced it was going to accept the tribunal's recommendation in relation to a planning inspector and gave a little bit of detail of what it was proposing. It said it was going to establish a new Office of Planning Regulator called the OPR with powers to carry out an appraisal of all statutory plans under the Planning and Development Act. So that would be the local area plans, the strategic development zone plans, I think, would also be covered by that, but mainly the development plan, which is the key provisions. It would also advise the Minister on the content of plans and, where appropriate, provide advice on all or parts of the plan should be directed to the mechanism of ministerial direction, which I've already discussed. But the interesting thing, and I'll just discuss this later, is what the government's proposal, as in their press release and as in the media reports as of the time, was that the final decision in relation to a ministerial direction would rest with the Minister. Now, I'll return to discuss that. It also indicated that the OPR would have a research, training and education role in the areas of planning identified by the Tribunal, and it also envisaged that the OPR would be staffed and resourced insofar as is possible by personnel taken on secondment or on a permanent basis from on board Planola. That's what ABP means. Now, again, we're dealing here with the government proposals at the time. We haven't seen any draft legislation, so I do enter that caveat. But the government proposals raise a number of questions. And the first question is, does it represent full implementation of what the Man Tribunal recommended? For example, the government statement indicated the Regulators' role regarding directions in respective development plan will be advisory. Okay? It will be advisory. The Minister will retain the ultimate power to make the direction. And the justification that's been offered by Phil Hogan, the Minister at the time, and the Junior Minister, was that their argument was that there must be political accountability in relation to the making of the decision, and they didn't feel that the ultimate decision being made by an unelected, what they would say is an unaccountable planning regulator, was appropriate in that regard. Now, the only thing to say about that is it's been the subject of quite a lot of criticism. For example, Michael Smith, who is one of the people who started the Planning Tribunal effectively by offering a reward for information on planning corruption, along with Colm O'Hucka, who's now a High Court judge. He has criticised this as saying that this is simply, not a planning regulator, simply a planning advisor, that the whole point of this of what Mahan envisaged was that you would depoliticise the issue of making directions, and that the whole point is that it should be removed from the ambit of a politician, and that decisions on directions and decisions as to whether or not development plans, and particularly the zoning provisions, are compliant or non-compliant with the law and with national planning, should be a technical exercise conducted by a statutorily independent regulator. And you can make that regulator accountable by simply providing in the legislation that the regulator should be accountable to the Oireachtas or to the Minister. Now, there are arguments either way in relation to this. The proposal does envisage, for example, that any advice by the regulator as to a direction or a draft direction would be published, which would mean effectively a regulator would publish that XYZ development plan is non-compliant and should be changed, and this would be published, and then the pressure would go immediately onto the Minister. And in those circumstances, it could be said that the Minister would find it very difficult not to adopt the recommendation of the OPR, and that there may in fact be an argument of saying that the political accountability in that sense is justified. The other element of this is there is no reference in the government proposals or the publications so far, or no great clarity about the powers of the Office of Planning Regulator, or the OPR, to conduct investigations, to question, witness and compel the production of documents, which, as you've seen from the quote that I highlighted, is something that Judge Mahan was extremely anxious and stressed that an effective planning regulator would have to have. Now, one thing that's not on the slides, which should be, is that just looking to the government
press release again, I just noticed that they did say that the regulator would have the similar powers as the Minister has under Section 255 of the Planning and Development Act, and Section 255 allows the Minister a statutory power to effectively request information from a planning authority, to appoint commissioners and to conduct certain investigations, but its powers don't extend to the essential powers of a regulator, which is, and this is why we had to set up a tribunal of inquiry, which is to give them strong legal powers to compel people to answer questions, to compel people to produce documents and furnish certain evidence which allows you to make a proper decision as to whether or not there's some impropriety. Now again, we need to await and see the publication of the legislation in this regard before we can make a definitive decision on that. But both of those bullet points there, both this issue of the ministerial residual power being retained in relation to the direction and the lack of compellability, are 2 points of some concern. And I think this is, if for people concerned with the efficacy of the planning regulator, this is something to watch out for in the legislation. Now, just to turn to some potential issues or some potential problems. One issue here is, always a problem with a regulator, is to give the regulator a precise scope and define its functions. And it's important that that will be done in the legislation, and particularly its role vis-à-vis the other actors within the planning system, particularly the Minister, the Board Penola, the local authorities, the department. And I should also have included in there the Ombudsman as well. The Ombudsman has an important function and has discharged it quite effectively in relation to investigating maladministration by planning authorities in terms of tardiness in discharging their functions. Now the question is, where does the OPR fit in relation to that? It's important, I think, to stress is that Mahon didn't envisage a kind of, and again we can discuss this later on, he didn't envisage a kind of an overarching planning regulator with the powers to investigate specific complaints from individual members of the public. Instead, he envisaged an oversight regulator with limited functions. And I think recognising the fact that individual decisions in relation to planning applications should be dealt with by the planning authority, by Board Penola, and if there's dissatisfaction with the decision of Board Penola, by way of judicial review. And it was not going to be the role of the planning authority to come in, the planning regulator to come in and start investigating individual complaints. Instead, it would be a more systemised approach. And I think that's probably the correct thing to do in relation to it. Now, it remains to be seen, obviously, that I think it's essential that the OPR would have some form of public complaints system. But again, that's something that needs to be carefully considered. Clearly, it needs to be statutorily independent, and hopefully that will be statutorily enshrined. The appointment process should hopefully be statutorily independent as well. The issue of accountability needs to be raised. Is the OPR going to be accountable to the Minister? Is it going to be accountable to the Oireachtas? My preference would be that it would be accountable to the Oireachtas or Oireachtas committees. Is it going to be subject to freedom of information and access to environmental regulations? Again, one would hope that it is, although it may be necessary to provide certain exceptions in the case of investigations. Obviously, the critical issue here is it has sufficient legal powers to discharge its functions, powers of entry, search and seizure, question witnesses and compel the production of documents, proper enforcement powers. I would be looking for a power to serve as statutory notice, requiring local authorities or certain people to do certain things within certain times, produce certain documents. Possibly some form of statutory injunction whereby mandatory orders can be sought or restrictive orders can be sought on a statutory basis on a civil power. And also enforcement powers on the criminal side, the power to instigate criminal proceedings and, if necessary, to prosecute. And what would go with this is appropriate sanctions, both civil sanctions, penal sanctions for non-compliance with the requirements of the legislation, penal sanctions for attempting to obstruct or interfere with the OPR, and also other forms of civil sanctions, I think, as well in relation to those matters. And I think there's scope for some innovation there in terms of the civil sanctions. For example, in relation to elected members who don't cooperate with the OPR, perhaps you should look at, should there be some power other than a fine, but also, for example, should they be required to resign office if they don't comply? Something like that could be considered in relation to it. Yeah, the other issue, of course, a key issue here is going to be the issue of resources. I mean, it's critical that the OPR has sufficient resources, because if it's under-resourced, that is problematic. And again, that combines both fiscal and human resources. As you'll see, the proposal is that some on board Pleanála staff, certainly, and local authority staff, I think, is envisaged may well be seconded to the OPR. And that's fine, because there's arguably some surplus capacity within board Pleanála which could usefully be transferred across. A little concern here I would have is that there is an issue here of independence, in that I think that while it's all very well and good to have staff drawn from the existing planning system, so to speak, for example, people from board Pleanála, people from the local authorities, maybe unlikely some administrative staff from the department, it's also important that perhaps there are some external staff from the private sector or from outside the planning system, or even from abroad, brought into the OPR to ensure that you don't have effectively regulatory capture or an inside too close relationship with the existing planning system. Also, I'm slightly concerned about the use of the phrase secondment from on board Pleanála, which connotates a kind of a transient or not a permanent organisation, which is a little bit concerning. There's also a problem, which I think is going to be real, of the OPR used as a de facto appeals mechanism. In other words, people that are unhappy with a particular planning decision will simply go and ring the OPR, start lodging complaints with the Office of the Planning Regulator and saying there is corruption here because of this decision. Now, again, there needs to be some form of mechanism where the public can bring to the attention of the OPR potential issues of corruption. But at the same time, there needs to be a filtering system to ensure that it simply doesn't become another appeal organisation or another point of appeal, de facto appeals mechanism, because otherwise it will be swamped. Clearly, there's the issues of retrospective or prospective application. One would assume it will only be prospective, it won't have any retrospective application. The big danger, I presume, which I've highlighted, is it just going to become another quango? If it's not properly done up, it could just end up becoming a very technocratical, functional quango, sitting in an anonymous office block somewhere, issuing directions which are ignored by the Minister for various different reasons. The other more fundamental question is, does it go far enough? Now, in fairness, Alan Mahan didn't recommend, or Judge Mahan didn't recommend, the establishment of something more radical, like perhaps a planning ombudsman, a much broader ranging, overarching regulator with real powers in relation to planning and to cover all aspects of the planning system. But that is a question that you can look at. Now, in terms of the possibilities to get a little bit positive for a while, the first thing is, there's no doubt about it that a proper resourced OPR could transform the nature of the planning system and address the problems we've seen in the past. It has the potential to remove politics from key elements of the planning system. I think the educational and research role that's been mooted for the OPR is really something that's much needed in terms of improving the quality of decision making and understanding the quality of decision making. It can very frequently be the case that proper research and publication of decisions can in itself be a very powerful incentive to ensuring absence of corruption within the system, or maintaining the integrity within the system. And also, we don't have a great deal of empirical or systemised research about decision making within the planning system. And the training and research can provide support to those who are committed to good planning. Moreover, really, the most important thing is that if it's done properly, your planning regulator can bring a culture change in the system. And that's really the key thing you need in relation to it, is to bring a culture change within the system. And I've referred to this as a kind of a sword of Damocles effect, which is, Damocles is...
Tom, sorry, that's 5 minutes now.
Sorry?
You have 5 minutes left.
Yeah, I'm just finishing up. Just in relation to the Greek mythology, so to speak, Damocles was a chap who, for various different reasons, sought power, but ended up in giving it on the condition that he would live out his life under the sword there, so to speak, which you probably can't see in the picture, which is held by a single thread of horse's hair. But the analogy is that people who are in power and get to exercise power, are subject to the condition that there is a kind of a quid pro quo for that, and that is that if they have to accept that in exercising power, there is a pressure upon you. And an OPR could operate as a kind of a sword of Damocles over the elected representative, so to speak. What you need is an OPR which is there so that people who are involved, and I include all actors within the planning system, be that the applicants, be it the landowners, be it the agents acting on them, be it the planning officials and the planners within the planning authority, be it the county manager, be it the elected representatives themselves, who are involved in decisions which involve the making of the plan and rezoning lands, know that at a future stage, their decision will be subject to scrutiny, and that scrutiny will involve them being compelled to answer questions, them being compelled to produce documents, them being subject to a rigorous investigation to find out whether, in fact, this was a bona fide decision. And there's nothing wrong. Zoning decisions and rezoning of lands can be done for very, very bona fide and solid planning reasons. There can be no question about that, or whether it was in some sense corrupt. So by way of conclusion then, and that really is, in my view, what you want an effective OPR for. Just by way of conclusion, therefore, this is really a once-in-a-generation opportunity, I think, at this stage. And the organisation itself must have a clear mandate, must have a clear function, must get the resources it needs. The legislation is absolutely critical, and that's why when the legislation comes out, it's important to have a look at it and scrutinise it, and that people that are concerned with ensuring there's an effective regulator look at that and ensure that that's the case. It really is essential to get the legislation right if we're going to restore public confidence in the planning system and address the clear recommendations of the Man Tribunal. So hopefully you found that of some assistance and of some interest, and it raises lots of issues, and perhaps we can discuss those in the questions afterwards. So thank you for listening.